For me, I like to give my clients the option. In some cases, the only way to move forward is through litigation and starting that court process by filing an individual petition for divorce. But some clients come to me and want to resolve their divorce amicably and outside of the court process. And so in those situations, I'll send a letter to the opposing party letting them know that my client wants to resolve the divorce amicably to see if they agree, and then what the deadlines are in terms of exchanging information so we can move forward in that fashion. We could also schedule a mediation with the mediator to help the parties reach an agreement as well.
It really depends on the complexity of your case and the issues that are involved. In other cases where there's financial issues, businesses to be valued, real estate to be valued, it may be helpful to get an attorney involved sooner rather than later.
I do stress to people that if they don't hire an attorney to assist them, that it is really important to have an attorney review the documents before they sign them. It's important that they have an attorney be involved before there's even a signature on the documents, even if they're not filed with the court, because it's hard to undo.
It is unethical for a lawyer to represent both sides in a divorce. It is unethical even if both sides agree to that lawyer representing them both in a divorce, and lawyers who have done that have faced professional discipline, including disbarment. So your lawyer represents one person and one person only. They do not represent you as a couple.
I tell clients all the time, don't put anything in writing you don't want a judge to see. That includes on social media, as well as text message, email, and it's not just to your opposing party, spouse, parent of the other child. It's even to third parties, because you have no idea if that third party is going to take a screenshot of your Snapchat messages that you sent complaining about the mother or dad in the case, and that could also end up being used as evidence in court.
As we all know, children do not come with instruction manuals.
It is very important that the children are not involved in the divorce process. They are children and should remain children. Parents should not try to pin one parent against the other parent, use the child as a way to communicate. The issue shouldn't be discussed in front of the children. Even adult children, I believe, shouldn't be involved. They should be able to have a relationship with both of their parents, not influenced by the other parent.
50-50 parenting alone isn't going to get you out of paying child support if you have that obligation.
There's a formula in the state of New Hampshire to calculate child support, and there's a worksheet online that allows you to input both parties' income into it. There are, for lack of better words, credits that are taken into account in the child support guidelines worksheet, whether you pay for the health insurance for the minor child or children, if you have a mandatory pension, state income taxes, child care expenses, and then a number populates at the bottom of the worksheet. There are factors that the court can consider when deviating from the guidelines worksheet, and it's really important to consult with an attorney about whether a deviation is appropriate in your matter, because there are several factors that the court will consider. In New Hampshire, you can proceed with a divorce in one of two ways. Irreconcilable differences cause the breakdown of the marriage. Essentially, both parties are just going their separate ways and the marriage is coming to an end. Or fault grounds, which essentially is that one party is the reason or is at fault for the marriage ending. There are several fault grounds that you can allege in the state of New Hampshire. The most common is adultery.
You may be getting divorced because of something that could be a fault-based ground. Whether you want to actually go through the whole process and litigate these issues in court is a completely different question. It makes the case far more contentious.
It is expensive and time-consuming and difficult to prove that fault grounds actually caused the breakdown of the marriage.
Those underlying issues can still be addressed even in a non-fault grounds divorce. So if you are just moving forward with irreconcilable differences, some of those underlying issues, adultery, whatever the case may be, can still play a role in the divorce case without having to prove fault ground.
There are a number of gray divorces. We're certainly seeing an uptick in people who have been married for 30, 40 years seeking a divorce. There are different considerations at times in these divorces. I mean, the same goal of dividing up the marital estate is what is important, but considerations of Social Security and retirement benefits, whether they're currently being paid out, are all factors that would come into play in a divorce when parties are either at retirement or nearing retirement age. I used to be of the mentality that prenups were unromantic. As I do more and more divorces, I do believe that prenups are a very effective tool.
More and more often I'm seeing people coming in that are just starting their careers. They don't know whether they're going to be inheriting anything, but they plan to have children or already do children, and they want to protect whatever they may leave to those children, and are really using them more as just a method of having some level of certainty in what will happen in a divorce, predictability and control, and not so much about just making sure that this other person doesn't take everything that you have.
I'm finding that prenuptial agreements are becoming more and more common for first-time marriages, and the reason being that the parties are entering marriages with significant wealth, savings that they want to protect. And people are getting married later in life, having had careers, have decent amount in their retirement accounts, and want to protect those assets.
The reality is that if you are not earning an income in a marriage, you are going to be deterred from filing because you are scared about what's going to happen.
Whether or not you have an income or not plays no role in your ability to file for divorce. It is going to play a role during the divorce process. If you have no income, that could play a role in the calculation of child support or alimony or property division.
And courts can put in place temporary child support orders, temporary alimony, and even address the use of marital funds on a temporary basis to get you through the process until you have that final hearing.
A business is considered a marital asset. Once the court determines what that business is worth, it is part of the general pool of marital assets, which would be divided between the two of you. It's important to know that in many small businesses, you can't divide a minority interest. Many small businesses have what I call shareholder agreements or LLC agreements that prevent members from transferring their interests to a third party. So what may happen is the court would say, if you own the business, you keep the business, but you have to give the other spouse something of comparable value. Under New Hampshire law, all property that is owned at the time of the divorce is all potentially divisible by a court. My advice is that if the item has sentimental value, it is something that can be negotiated as part of a property division.
A lot of times in these cases, we miss the why of why people want or are fighting so hard for certain things. And if you just give that explanation to the other side of why something's so valuable to you, you're usually surprised by what their response is. Because there is no way to protect those sentimental items, you want to be thinking about it early on and discussing it with the other party early on.